The state capture inquiry has been 4 years in the making, and earlier this week the chair of the commission, acting Chief Justice Raymond Zondo, handed over the first part of the 3 installment report. In it, the commission recommends the formation of an anti-corruption agency to minimize graft and increase transparency in public procurement processes. But with the country's corruption already at worrying levels, is it perhaps not too little too late? And how exactly would an anti-graft agency operate? To help us look at this, I'm now joined by legal analyst Mpumelelo Zikalala. Kuzeni, thank you so much for your time today. Some say that this agency will be a good idea in theory, while others are saying it might not just work. What are your thoughts on it?
Thank you, Mangete. Good afternoon to you and also to your viewers. We are basically rehashing and creating another institutions when you haven't critically analyzed what is wrong with the current institutions that we have. Maybe let's break it down into 3 parts. Let's start with the applicable legislation that governs or which is meant to make sure that we're able to prevent corruption and able to deal with it whenever it raises its ugly head. We have the Public Finance Management Act, which basically deals with how finances are supposed to be handled in any public institutions. If you look at maybe starting from Section 81, moving on to 91, it tells you exactly how to deal with people that didn't comply with it. It tells you how to deal with people that have flouted and have caused that there be irregular expenditure or wasteful expenditure. And there's basically some sort of punishment in which they're supposed to suffer. Similarly to when it comes to municipalities, the Municipal Finance Management Act deals decisively with what people are supposed to do when it comes to not doing things according to the law. Now, let's then move on to your law enforcement agencies, or let's call them the foot soldiers that are meant to prevent corruption. First of all, SABC, there's an applicable act applicable to them as to how they're supposed to do things. You then even have the SIU, Special Investigative Unit, which even has its own powers of creating sort of intermediate processes so that we're able to investigate and prosecute things easier and quickly. Similar to that is what we've seen when there were COVID-19 irregularities that have taken place. And we've seen how swiftly it was for the president at the stroke of a pen to create this particular tribunal so that at the end of the day, we are able to find those wrongdoers and we are able to recover the money. What is another concerning factor is this. If you read the report from page 1 up until this particular recommendation unit is made, there are no utterances as to the inefficiencies of the current institutions that we have, ones that I've already alluded to earlier. There may be certain signs here and there when it comes to the PMFMA as to where it's not working optimally, but it doesn't say anything else about any other institutions. We can draw only one conclusion to that, saying that the legal framework and the structure and the legislation is okay. There may be a few instances where we would need to amend them, but where the problem is, and the elephant is the room, is the implementer of the particular legislation. They are the people in which we're supposed to change.
And when you then look at that and you read the report as well, as you say, part of what I see as a criticism is also the issue around the NPA and how the report really hits hard at some of the work that should have been done by now, even going as far as to say, the chairperson laid a complaint even with the NPA against former SAA board chair Dudumieni for mentioning a witness's name in the commission, and nothing has happened, and talks about even the NPA really seemingly battling at a fundamental level of even dealing with some of these cases. I wonder then, this particular unit, because when you look at what he also says, is the very question of where should it sit? Who should preside over it? And says that, should it be a minister? Is that safe? Is it not going to be? So I wonder, where does a unit like this then sit in order for it to really be as efficient as it needs to be?
I think one of the very first lines in the report saying that it must be constitutionally only be accountable to the Constitution and the law. It may suggest that maybe let's brand it in or put it under Chapter 9 institutions, which would basically mean that we need to amend the Constitution so that it is included. Now, the question then is, are you going to find the political will to do that? Since if you have to change the Constitution, you need parliaments so that in the legislature, so that that particular amendment is then effective. But the point is this one. You are trying to change or to solve a problem by removing a symptom which is not really there. The symptom in this case is that the legislative framework is okay. It's the individuals which are a problem. As you have perfectly alluded, the NPA was supposed to be called to the Zondo Commission and to say and ask them, are you finding difficulties in terms of prosecuting these particular matters? Let's then move on to the law enforcement agencies, SAPS, SIU, even the Ops. Are you finding any issues in terms of investigating? Are there certain people that are preventing you from doing this type of investigations? If they are, let's deal with them decisively so that at the end of the day, you are able to maneuver and deliver results at the end of the day. What is required by the people of South Africa is that you must have people which are going to be arrested. Most importantly, recover the public funds because it is public monies which are supposed to be used for public initiatives. So those are the two most critical things which are supposed to be there. But another factor is this one. The report is also silent on the role of the oversight individuals that are supposed to be there. In particular, political appointees, ministers, deputy ministers, MECs, who are supposed to make sure that in their political role, they are then checking what are the accounting officers doing when it comes to these particular matters. If they are silent on the matter, if you have parliamentary committees which are not going to be decisive on these things, if we are going to have SCOPA or even MPAC not making determinations as to how people are supposed to be punished, then that's where our problem lies and not with the legislation.
So I'm listening to what you're saying, and there's been quite a lot of concern even about the capabilities of this particular agency, should it be formed, to be able to investigate cases, that are specialized like this, because we've seen, that the concern has also been about the fact that corruption is caught right at the end instead of when it begins, and systems are not able to detect. I wonder then, if you then move a level up, does it then look like for something like this to work, we may need specialized courts that are purely focusing on corruption cases?
Definitely, you would need on two bases. One, the people who are going to be prosecutors in those specialized courts they then are able to gain experience so that they're able to act on matters swiftly. They can manage to close loopholes much more easier than an ordinary prosecutor would do. But the most fundamental question is that if you then go into the Special Investigatives Unit and Special Tribunals Act, that's the trigger. That's where you find an opportunity for you to create these specialized courts. That's where you find an opportunity for you to make sure that these type of tribunals are done. We've done it in not less than 6 months ago when it came to COVID-19 procurement procedures and people that have flouted procurement rules. And it has seemed to work if you then listen to the SIU reports. Yes, there may be inefficiencies here and there. There may be instances where they haven't been able to recover, but at the end of the day, there is some sort of impact that this particular special tribunal has been able to make, which comes back to my point. The machinery, the legal framework for us to do what is being proposed with this recommendation, it is already there. All that we need to do is to enhance it with making sure that we close any legal framework loopholes that may be there. But most importantly, let's get the right people to do the job so that at the end of the day, they're able to produce results.
All right, Kuzen, it looks like this might be an uphill battle to then be able to argue for this particular agency, especially when you look at the legislation that you've just also says needs just some enhancing and not seemingly just dealing with the symptom. But thank you so much for your time this afternoon. That was legal analyst Mpumelelo Zikalala.